Good afternoon, everyone, and thank you for joining us on the first of hopefully many webinars that we will present that have nothing to do with COVID. So I'm looking forward to that, and as always, my friend and partner Ryan Conlin will be joining me, and we'll be presenting about some proposed amendments that the Government of Ontario has introduced in the legislature, and we're going to be keeping a very close eye on these. We are hopeful, as you'll hear, that the government thinks about these proposals in greater depth, and that these spend some good time in committee before they are rammed through in sort of a slipshod manner, as there are a number of, at least in our view, significant charter and other considerations that should weigh in. The Working for Workers Act 2022, another one of these bills that has a fancy name that makes it sound like it's all good stuff that's coming out and nothing that anyone would possibly have any concerns about. And the majority of the discourse out there has been about the employment standards and related changes, everything from the right to disconnect to questions about whether non-executives can be subject to non-competes and things like that. We're not going to be dealing with that today. We're going to focus solely on the proposed amendments that will affect health and safety, because other than in our articles and a few other folks out there, these have not, in our view, been receiving a significant amount of attention, and hopefully they will. So without any further ado, I'll hand the conch over to Ryan.
Hi, and good afternoon, everyone. So we're just going to try to take you through, what the proposals are. An emphasis on these are proposals. It's not legislation now. We also have an Ontario provincial election coming up in June. I anticipate that the legislation will pass. The Ontario government it's a majority government situation. So generally speaking, if the government bill is presented and there's will on the part of the legislature to pass it, it generally does. However, so just a couple of things that we want. One of the key changes is the increase in the maximum fine, raising the maximum fine for individuals from $100,000 to $500,000 per count. That is a fivefold increase, a very significant change to the legislation. In fact, that is the maximum fine that historically had been imposed on corporations up until a couple of years ago, when the fines as it pertained to corporations was increased. So that's a pretty big change, and I think I want to make it clear to those of you who are out there who wonder, are individuals ever charged under this legislation? And the answer is they are. The Ministry of Labour very routinely, and Ministry of Labour Skills Training and Development routinely lays charges against individuals, most commonly supervisors, but certainly also against workers, and more rarely against officers and directors. And that's where we get to the next change. For officers and directors, the maximum fine would increase 15-fold to $1.5 million per count. This is the same maximum fine that is applicable to corporations in the province of Ontario, and in my view signals potentially a legislative change for an entirely different sentencing regime, potentially for officers and directors, particularly for repeat offenders, that I would imagine, if I were sitting in the shoes of the Crown prosecutor, I might be saying on sentence that that the legislature is signaling a intention to sentence officers and directors in the same sort of range of fines that have historically been imposed against corporations. Now, as defense counsel, I'm not saying that's a position that I would accept, because it isn't. I think there's certainly a lot of case law out there that we'll get to this in a moment about how maximum fines work and what that means. That certainly perhaps that it could be argued that the increase in the maximum fine is a suggestion that worst offender should be sentenced in the range of corporations. But that is a debate that undoubtedly will be had with Ministry of Labour prosecutors in the courts in the future. So I think it's certainly something that officers and directors at that level in Ontario should certainly pay attention to. It's probably the most significant legal change in Ontario in health and safety as it pertains to officers and directors since the Bill C-45 amendments to the Criminal Code, which were very much officer and director focused, came into force almost exactly 4 years, almost exactly 18 years ago, back in 2004. So certainly, and my only really other comment around officers and directors is, unlike employers and unlike supervisors and even constructors, there's not a huge body of law out there that relates to what exactly due diligence looks like in the executive director kind of context. I mean, in my view, the leading case remains R versus Bata, for the Bata shoes, which is a rather dated environmental prosecution that dealt with the owner of a shoe manufacturing facility. So, I mean, again, it's so when I think there has certainly been prosecutions, regulatory prosecutions involving officers and directors, but they're not particularly ones where we've got some really detailed comments from the courts about what due diligence means in that circumstance. They're not out there, but certainly there is a body of law, and a lot has been written on executive due diligence in the regulatory context over the years. But I think it's probably time to dust that for officers and directors in light of these potential changes. And even if for some reason these changes don't go through, it remains a good idea for officers and directors to make sure they're up to date on health and safety due diligence, because this could suggest, it's hard to say, but prosecutorial discretion being what it is the ultimate decider as to who gets charged. But if the fines are up, it certainly could signal a possibility that we see more charges against directors than we historically have in the province of Ontario. Next slide. So what is the impact of a maximum fine change? Certainly, you can anticipate, in my view, that Ministry of Labour prosecutors are going to suggest that an increase to maximum fines means that the case law under the old regime is not particularly relevant to sentencing to sentencing to higher fines. And certainly, there's been kind of a debate in the courts about that issue. None of these cases on these slides are from Ontario, but there's two cases, R versus Hoyek, which is from Nova Scotia, and another province case called Gibson Energy. Hoyek was a rather well-known case that was originally a criminal prosecution in Nova Scotia, and eventually ended up proceeding under the provincial legislation out there. But ultimately, what those two cases essentially say is they basically accepted the prosecutor's position and say, look, the legislature has increased the fines. The older precedents are of less relevance. We need to look at an increased regime of fines because the legislature has increased that penalty. A Saskatchewan court came to the opposite conclusion in a case called Carrier Forest Products. In Carrier, the court said, look, just because the maximum fine increases is not really particularly relevant unless you're dealing with an accused that's coming before the court where they are likely to be subject to the maximum fine. And we'll get into sentencing factors later on in this presentation. But employers that are likely to be subject to a or parties that are likely to be subject to a maximum fine are those that have a prior record or a particularly serious or egregious case that was somehow not prosecuted through the criminal courts. But usually you're looking at a maximum fine with and also of course the resources of the accused, which is more relevant in the corporate context. But that's another issue that comes out. But where it's a particularly flagrant violation with an offender with a record is one that's more traditionally likely to be subject to a fine on the higher end, whereas a first-time offender not usually subject to the maximum fine. The court in Carrier Forest Products pointed out, and certainly defense counsel would point out, that if the legislature intended on wanting to increase the fines for first offenders, then a minimum fine could have been imposed, which wasn't the case. Next slide. So, I mean, what does this basically mean for corporations? I mean, one certainly, and the Bata case talks extensively about this in terms of officers and directors. There's no prohibition on a corporate entity indemnifying an individual for the cost of a fine imposed by a court, as in some sort of corporate law development to the contrary or amendment to the act. The legislation hasn't existed, so it may very well be that officers and directors want to contract for indemnification, not only for fines, but also for legal costs associated with independent legal costs associated with the defense of these charges. It is something that, as I said, it's a relatively it's certainly something that many officers and directors, and obviously not just for health and safety, but various other legal ramifications, and certainly the ins and outs of how indemnification language works and what the limits of it are frankly is a topic for a different day. And Jeremy and I talked about that we are going to do a session in the not too distant future on sort of corporate officers and directors looking at the criminal stuff and some of the more things I just can't get into in that level of detail today. But the bottom line, just thought I would flag that issue for you. All right, so that's the topic on maximum fines. I'm going to turn it over to Jeremy to talk about the limitation period issue.
Thanks, Ryan. So, yeah, I mean, Ryan and I we're sort of students of this stuff. We enjoy getting down into the minutia, and hopefully some of you out there enjoy it as well. And we can hope to see you at our program that we do a little bit more of a deep dive into officer and director liability in the context of health and safety and things that officers and directors and corporations can do to protect them. The next topic of this presentation, though, is the limitation period increase. And so at face value, all this means is that the government can spend longer looking into the potential for laying charges, or if the facts giving rise to potential charges take longer to come to the attention of an inspector, then it may extend the amount of time that there is for bringing these charges up to 2 years in this case, from 1 year as it stands currently. And in our experience, I mean, Ryan and I have had over our relatively lengthy careers at this point, we've had a number of clients who have been under the cloud of a ministry investigation following accidents where the cause of the accident to anyone who had their eyes open should have been readily determinable. Despite that, the ministry and the inspectors have continued their investigation over lengthy periods of time, have issued orders even after many months following an accident, that the employer disclose records or conduct investigations, retain experts to determine what the cause of an accident was, or direct that the company conduct at its own cost non-destructive or even destructive testing and produce a report. These are the sorts of things that the ministry inspectors, while they are conducting their inspections of a workplace to ensure compliance with the regulations, have the power to order, and their authority is very broad. But once they cross that, it's called the phrase is once they cross the Rubicon, which in taking away the legal parlance means they've now reached the point where they have reasonable and probable grounds to believe that an offense has been committed. And the point in the investigation where that occurs can differ depending on how obvious it is, how many investigations the inspectors have on their plates, when they start reviewing that data and documentation and evidence. And so what we don't know is, just because this limitation period has now been extended to 2 years, does that mean these inspections that used to, or these investigations, or the time between an accident or alleged violation and the actual laying of charges, will that go to the 11th hour as it used to, but now 2 years after the event instead of 1 year after the event? So one thing that Ryan and I even had some cases that the ministry actually has 30 days after the information has been sworn before a justice of the peace to serve that information on a defendant. So you have 1 year currently to lay the information, and then you have 30 days to serve it on the defendant. And the extension of this to 2 years means it's actually 2 years plus 30 days to serve it. So if you're a potential defendant, you're going to have this cloud hanging over your head for potentially up to 25 months before you become aware that you are now the subject of a prosecution under the Provincial Offences Act for health and safety related infractions. So up until now, there has been a controversy about at what point the ministry inspectors may continue to use those broad inspection powers. And from time to time, Ryan and I have had to write very diplomatically, carefully worded letters to the legal department and the inspector in a matter that has been under investigation for a very long time, and essentially take the position without admitting wrongdoing that the causes of the accident at this point should be abundantly clear, that the inspector giving directions which they can only give without a warrant pursuant to their inspection powers, that we've crossed that Rubicon and they ought not to be utilizing those powers any further, and they ought to go get a warrant. The downside of taking that position, of course, is number one, you're not admitting, but you're showing your hand a little bit to the ministry. You're saying to them, look, we know you're coming after us. We're circling the wagons. Number two is that if you're wrong and they haven't crossed the Rubicon, as they say, this could be construed as obstruction. And if you obstruct, then you can be charged just for obstruction, even if you weren't liable for any infractions under the Health and Safety Act otherwise. And so whenever you consider writing a crown or an inspector and resisting complying with the direction or order that you produce something or disclose something or present for an interview or retain an expert to conduct an investigation, etc., you always want to get legal advice, but it's not that it's impossible to do so. The question now, though, is if you've got 2 years, does that mean that the ministry has 2 years to utilize its inspection powers? And arguably they do. And so this may create greater jeopardy for a defendant or prospective defendant in a long period of investigation where, especially after a year, if the ministry doesn't have what it needs by then to have reasonable and probable grounds, and it's been investigating the matter, when exactly will it have reasonable and probable grounds, right? So we're going to be dealing, I think, with a lot more of these cross the Rubicon letters, and we may be dealing with other issues of whether the government misused its inspection powers, the Rubicon was crossed, and evidence gathered for which the government should have sought a warrant should thus be excluded from the record. Another issue is one of pre-charge delay. So for those of you who have joined us for prior presentations, where we've talked about a case called R.V. Jordan. So the Jordan was a decision that went up to the Supreme Court of Canada, and this is where the government said, look, we've got essentially a serious issue of charter rights being violated in the right to a fair trial, and in the case of defendants who may be facing jail time, their Section 7 charter rights to security, life, liberty, security of the person. And so what we're going to do is establish some per se thresholds, and those thresholds will set a number of months beyond which the presumption will be that charter rights have been violated, and the defendant will be entitled at law to a stay absent certain exemptions. And because this presentation is not really about Jordan or those sorts of things, I'm not going to get into great detail, but essentially for provincial offenses matters, that is 18 months of post-charge delay between the date on which the information is laid and the date of the end of trial. That is the period during which, excuse me, that's how long a trial should take to come to its conclusion following the laying of the information. Anything longer than that, there's an assumption that the accused charter rights have been violated and that there should be a stay of proceedings, which is better than an acquittal. It means that charges really never happened. The whole thing goes away, okay? And the real issue after Jordan, one of the issues was, well, what happens to pre-charge delay? So in criminal matters, in some cases there are limitations, but often in indictable offenses there are not limitations, in Canada at least. But in provincial offenses matters, there were deadlines set, right? So it used to be, it currently still is 1 year. And so what the courts, all the way up to our Court of Appeal, have essentially found at black letter law at this point, is that pre-charge delay will not be counted and cannot be used as a basis on its own just because of the passage of time. As long as that passage of time is within the set limitations period in an act, like provincial offenses and health and safety, they can't use that as part of the Jordan analysis. It's not going to be part of the 18 months that leads to a stay if it goes beyond, and it's not going to be relevant to the Section 7 or Section 11B right to a fair trial analysis. However, there remains a doctrine of abusive process, which the courts can still utilize. And so it's not going to be, you're not going to be permitted as a defendant to say, well, the Crown took too long, the ministry investigation didn't have to go so long. The court's not going to get involved under the current state of the law in parsing how quickly or how efficiently the Crown did its job. Neither is the court going to look at what point, at least in the context of a motion for a stay, at what point did they have reasonable and probable grounds, and they really should have laid charges at that point and not utilized the remainder of the limitation period because of that cloud over the defendant's head. There will have to be evidence of actual abuse of process. And really, we're talking about evidence of bad faith, which, at least in our experience, these things are usually more about overwork, too many files on their plates, or a lack of a coordinated approach to investigations between the investigative branch and the Ministry of Labor and the prosecutors. You're rarely going to find any evidence, and that's a good thing, right, for our system of justice, where there's been actual bad faith on behalf of the Crown or on behalf of the inspectors involved in an investigation. So again, there may be grounds for looking more closely now that the limitation period is longer, especially if inspection powers are utilized beyond when they probably should have been. But it's going to be a very high bar to pass to demonstrate that a stay of proceedings should be implemented as long as the charges are brought within that 2-year period. And now I will pass the conch over to Ryan to start us off on the new mandatory sentencing factors that the courts may be required to follow.
All right. Thanks, Jeremy. It's interesting to see. I mean, if there's ever a case that's well known in health and safety circles and well known to the regulatory courts in Ontario and frankly across Canada, it's the decision of the Ontario Court of Appeal in R versus Cottonfells. It's by far the leading sentencing case that's been cited literally thousands of times in courts across the land as to what are the factors that are relevant to sentencing a corporation under regulatory statutes, and some of the factors that apply in Cottonfells have been also considered in terms of the sentencing of individuals in regulatory statutes as well. As you'll see in the next slide, this is just the passage that's been read to judges literally thousands of times. I mean, again, you'll see that Cottonfells deals with a corporation, but some of the actual some of these factors are relevant in sentencing of individuals as well. The amount of the fine will be determined by a complex of considerations, including the size of the company involved, the scope of the economic activity and issue, which refers more to the resources of an individual in certain contexts, the extent of actual and potential harm to the public, and the maximum penalty prescribed by law. And then it says, of course, the main thing is to enforce regulatory standards by deterrence. And when the court refers to deterrence, it refers to both the community, both to the individual defendant before the court, and to the in general deterrence to the broader community of supervisors, officers, directors, and companies out there that are sentenced, which is part of the reason why the convictions in these matters are publicized, have at least historically been publicized by means of press releases and such, where publicly available on the internet, sort of the name of the defendant, the nature of the circumstances of the offense, and the amount of the fine, whether it by way of a joint submission, by way of guilty plea, or a finding of guilt following a trial. The legislation has come out to sort of incorporate things that are mandatory for a court to consider on sort of sending out a checklist, so to speak, rather than just sort of the more general factors that are set out in Cottonfells. I mean, and some of these factors aren't new and are routinely considered by courts and prosecutors when considering what the range of the fines are. There's a textbook that's published by current and former Ministry of Labor prosecutors that has a huge, literally thousands of sentencing cases listed, and it lists sort of the size of the fine, the nature of the injury at issue, the nature of the offense, the amount of the fine, maybe a brief description of the event. And those are, sort of a summary of what has historically been relied upon, certainly by counsels during negotiations, and sometimes the courts as well, to get a sense of what the range of fines that are imposed for a particular type of case. So the first one is does the offense result in the death, serious injury, or illness of one or more workers? Obviously, the more workers involved, the more serious the accident is, the higher the fine is going to be. The most serious is going to be in deaths, but situations where a worker is critically injured, or is which is sort of it's always been a sort of an odd definition under the regulation that sort of speaks to reporting obligations. But when you're looking at serious injuries, like someone who's been paralyzed, someone who's so if it meets the definition of a critical injury, it's not necessarily determinative, but ultimately the worse off the person is, the higher the fine is going to be. Two, that the defendant committed the offense recklessly. This is an interesting category, because we have to remember there isn't really a mental element in terms of a conviction for an occupational health and safety statute. It's basically in most cases, and there are some exceptions to this, but in most cases under the Occupational Health and Safety Act and other regulatory legislation, the prosecutor is bound to prove the contravention occurred. I mean, simple examples, common charges, machine guarding. Well, the machine was guarded or it wasn't. Right? It's not in order to establish the actus reus of the offense, in order to shift the burden on the accused to prove due diligence. All the Crown has to show is, was the machine guarded or not? If someone got their hand in the machine, it's the position of the Crown in most courts. Well, then it wasn't guarded. Then wasn't. Fall protection, similar thing. If someone fell for more than 3 meters, they weren't wearing fall protection by definition. Says a case called Seeley and Arnell aggregates, which has been cited many times, and that's basically all the Crown has to show. It sort of gets back to what Jeremy was saying, that in some instances the causation of the accident and the potential charge is like readily obvious in some circumstances. But recklessness is a different story. This is where the Crown has the burden of proving aggravating factors on sentence beyond a reasonable doubt, pursuant to a very old Supreme Court case called Regina versus Gardner. And essentially, in this instance, this will show, this sort of introduces at the sentencing stage, rather than just did the event happen or not, was the accused reckless? Was, like, if you take a guarding case, for example, had the employer been warned that there was a guarding issue? Had they ever conducted any inspections? Was this done? Was there an element of recklessness? The employer ought to obviously have been aware that the guards should have been in place and it wasn't, or that there was events where workers were removing guards, and it was happening all the time. The employer knew about it and did nothing about it. Maybe it's a signaling case where an employer is well aware that construction equipment is moving backwards without someone guiding it back as required by law, and it's happening over and over again. That's maybe for example, someone was allowing a construction vehicle to back up literally all day for hours. It was obvious to everyone on site that was happening. Nothing happened. That would make the employer or the supervisor of that individual arguably reckless, and points to a higher fine, which may very well mean in some instances that if there's a contested sentencing, it may very well be that the question before the court, once you get to sentencing, is obviously not so much that obviously the accused is guilty, but was the accused reckless beyond a reasonable doubt? And that may make a significant difference to the fine. Defendant disregarded an order of an inspector. Disregarding the order of an inspector is a serious offense in and of itself, and has been certainly charged where the Ministry of Labor issues an order or requirement under the legislation, and the employer has violated it. They can be charged for that. But if an accident occurs, if there's some other, and if that was if it goes beyond just the actual count related to the violation of the order itself, it's not surprising that's going to point to a higher fine. That's the kind of situation that may actually result in a criminal prosecution, frankly. Ignoring the order of an inspector is a very serious matter, and not surprisingly would point to a higher sentence for related offenses, as well as a pretty significant fine in terms of the actual offense of disregarding the inspector itself. Next slide. Moving, number 4 probably surprises no one, that if you have a defendant had a prior record under the Occupational Health and Safety Act, that points towards a higher fine. That's always been the case. It's always just a basic principle of regulatory and criminal law that you have a prior record. You come before the court, and it surprises no one that you're going to get likely get a higher fine. I mean, the actual impact of a specific offense has historically, courts have really looked at those offenses as to see, are they similar in nature and how much time has passed? I mean, certainly an offense that was 2 years earlier is much more significant than a dated offense from 20 years ago. But the other thing to be remembered, and this has been the case now for a number of years, thanks to earlier legislation, that if an employer, for example, has offenses under the Environmental Protection Act, for example, or Water Resources Act or others, like, in other words, if the employer is a bad actor under provincial regulatory legislation where they've been convicted of other things, that's where the court's going to say, hey, the court's going to point to that and say, look, we're going to impose a higher fine here. This is someone who has been before the court on related public welfare legislation, which which in the workplace context is oftentimes occupational health and safety, but can be workplace safety and insurance, can be employment standards, and for example, failing to pay wages, and certainly the whole host of environmental statutes and things, taxation statutes and things along those lines. So certainly that can be challenging. So that's certainly a factor that isn't surprising, and certainly if an employer that has a record like that, it's going to point to a higher penalty, and is the case irrespective of these proposed amendments. Number 6 is a bit more of a challenging one. This is one where the defendant lacks remorse. It becomes to me, like, if you read our article on this subject, we expressed a couple of concerns about that. Certainly, there's no question that no one would certainly. It becomes kind of a tricky thing, like in terms of a legal principle. But I mean, the bottom line is that it's always been a mitigating factor on sentence if an accused pleads guilty and saves the taxpayers the cost of a trial. So an early plea is always something that points to a lower fine and is an indication of remorse. But the opposite is that the opposite is, though, that it's certainly not an aggravating factor for an accused to exercise their constitutional right to go to trial and ultimately be convicted. They're not entitled to the so-called discount for remorse for pleading guilty early, but there's not a penalty. I mean, that becomes very tricky, right? I've certainly had many clients ask me over the years, okay, so if we don't, how is it not a penalty if we don't, how is it not an aggravating factor? And I say, look, it becomes kind of confusing, but at the end of the day, having a defendant lacking, assessing the remorse of a defendant is kind of a difficult, is kind of a difficult exercise. And one that I think this is just an unfortunate provision. I think that if you want to deal with this, I think it's got to be very much similar to an early plea. That evidence of remorse is a mitigating factor, but a lack of remorse ought not to, in my view, be an aggravating factor. There's difficulty proving it. We reference some comments in our article from courts on that subject. So, in my view, that's sort of a problematic and challenging thing for a court to do, because I don't think you're gonna have too many defendants and come out and say, yeah, I'm not at all remorseful. I mean, you can infer it from their conduct, but I mean, really at the end of the day, I think it's an unfortunate inclusion as a sentencing factor in this context. Number 7 is there is an element of moral blameworthiness in the defendant's conduct, and Jeremy's going to take the conch and talk to you about that factor.
Thanks, Ryan. First, just to echo what Ryan said a moment ago, one of our chief concerns with some of these proposed amendments is that the province is the government is proposing to take factors which ordinarily could only be used by the defendant as mitigating factors, and now to turn them on their head and to show that the absence of some of these factors is now somehow evidence that can be used as an aggravating factor on sentence. And of course, the difficulty with that is this has been the case since we had a free and democratic society quite some time ago. You have the right to say, I'm not guilty, and to force the Crown to prove that you are guilty. And so the right to remain silent plays into that, the right to say not guilty and to require a trial. None of these things are supposed to be held against the defendant, who's not guilty until they're proven guilty, and their constitutional rights are to remain silent when they are charged and or cautioned, and to a trial to force the Crown to prove beyond a reasonable doubt that they are guilty. And so some of these provisions are concerning because if they pass as drafted, it creates really a strong, almost punitive measure built into the constitutionally protected right to a fair trial and the right to make reasonable answer and defense, even if ultimately you're found guilty. And I think that we've cited some of the case law in our article, but all the way up to the Court of Appeal, they have expressly held historically, not with reference to these proposed amendments, that to use these factors as aggravating factors would trample the constitutional right to make full answer and defense and to plead not guilty. And that's not something that our justice system really ought to countenance, in my view. And frankly, I suppose we're lucky that even if these provisions come in, all legislation is subject to potential charter challenge. And given the forceful comments and findings from courts of appeal and all the way up to the Supreme Court of Canada on the danger to that constitutional right to make full answer and defense and to have a fair trial and the right to a free and fair trial, objective fair trial. Given the potential impact, negative impact there, I should think that if these provisions pass as drafted, it won't be difficult for defense counsel to mount a forceful argument that relying on any of those mitigating factors would be a violation of the charter rights of the accused. But I'd rather not have to make those arguments. I'd rather that the committees read the decisions from the Court of Appeal in Ontario and elsewhere and moderate this language and return to a little bit more of the status quo on factors that can be used in mitigation of sentence versus factors that ought to be aggravating, and properly so. So one of these linked to what Ryan was talking about, element of moral blameworthiness, right? So we've got the defendant lacks remorse. Well, what's a sign of lacking of remorse? Moral blameworthiness, right? So we're talking about mens rea here. We're talking about knowing that what you did was wrong. We're talking about what typically would be a standard applied in a criminal proceeding. And so if the prosecution is now going to be looking at ways to establish moral blameworthiness, one of those ways will be either in trial or in a Gardner hearing to ask questions which relate to what was known, whether or not these decisions were made in order to, as in number 8, motivated by a desire to increase revenue or decrease costs, whether this was known by the accused, in the case of an executive or a director, were they made aware when the minutes of a joint health and safety committee were were given to them, they were made aware that they would have to spend a certain amount of money in order to fix something and they decided not to spend that money that year. Is that moral blameworthiness, or is that a business decision that was taken because following an assessment of risk versus investment? These are the sorts of things that we're going to have to look at now more carefully if the Crown is going to be required, following a strict liability finding of guilt, to prove moral blameworthiness. I mean, in some cases, we have absolute recklessness. Ryan gave some examples where recklessness, really even before these proposed changes, reckless conduct on behalf of an accused have been used as aggravating factors in the way that the court assesses the seriousness of the offense, right? So if there were inspectors who visited and said, hey, you don't have a safety fence there, and the employer doesn't put up a safety fence, and then somebody gets hit by a reversing vehicle because there's no safety fence, well, that's reckless, and the courts already would impose higher fines. The question of whether there's a moral blameworthiness, though, now we're treading on territory that really is more appropriate, at least in my view, to the criminal context of criminal negligence in relation to health and safety matters. So as someone who has supervision over a worker or a workplace, so this is concerning that we're now getting into the sort of moral stigma that would typically apply only where we're dealing with a criminal offense being charged. In number 8, the question whether they were motivated by a desire to increase revenue or decrease costs. I mean, how is that not essentially the same as the factors that are already considered in these matters? The court would be obliged to consider the motivation of the accused as a practical matter. This is now getting into the mind of the accused, as opposed to simply looking at whether there was likely a motivation or there was evidence that somebody was cutting corners or something like that. Then it still relates to a sort of a different thought process and a different level of proof. As Ryan said, the Crown has to prove these beyond a reasonable doubt in order to establish them in a Gardner hearing or on sentence as aggravating factors. A couple of additional factors under number 9. These relate to the conduct of the accused after the commission of the offense. In one case, it's where the defendant has attempted to conceal the commission of the offense, and in the other, it's where they fail to cooperate. And I think each of these are very concerning as aggravating factors. First of all, if you're actually obstructing justice, so you're actively concealing, you're trying to destroy evidence, you're failing to report, for example, when there is a notice required, a report to the ministry required under the, for a critical injury or a fatality or something like that, then there's a positive obligation to report. If you fail to do so, you can be charged, and that's what that is for. Now, whether or not that's an attempt to conceal will now be a question for a sentencing hearing, potentially, and a Gardner hearing, where we're going to look at whether the employers intentionally chose not to report when they were required to do so because they were trying to conceal the commission of the offense, rather than this simply being a straightforward, strict liability offense of failing to report when there was a legal obligation to do so. Now we're going to have to look at the mens rea, the mental aspect. Was this done in order to conceal the truth, as opposed to grounding a separate obstruction of justice charge, which can be criminal, right? I mean, if someone is guilty of obstruction of justice, of destroying evidence or concealing something actively in bad faith, then you can be criminally sanctioned for that. You don't need this to be considered on sentencing in a provincial offenses matter. If you can make it out, then charge it. Finally, the idea that you would have failed to cooperate, and this is highly problematic. As we point out in our article, this similarly is contrary to the entire foundation of our system of justice, right? You have the right to remain silent. Once the ministry has an obligation, the inspector has an obligation, once they have reasonable and probable grounds to believe that you've committed an offense, they have to caution you that you have the right to remain silent. That's the law. And if they fail to do that, then anything you say, anything you give them might be excluded for good reason, because it's a violation of your charter rights. So at what point are you required to cooperate? At what point are you required not to cooperate? At what point, over a now potentially 2-year limitation period, are you allowed to say, we're not going to give you any more documents without a warrant? Is telling the ministry, short of obstruction, so you're not obstructing, they don't have a basis to prove that you're obstructing the inspector, you're refusing to comply with a valid order, but you're still not doing more, right? So failing to cooperate means more than actual obstruction of justice, right? Cooperation means evidence of good faith, helping out in the investigation, providing documents that haven't been asked for, doing things that you might not be legally obliged to do. How, in the context of a regulatory investigation and prosecution, can a defendant hold on to their right to remain silent? How can a defendant hold on to their right to ensure that there is a fair and impartial trial? If they're also obliged to cooperate, and failing to cooperate might lead to aggravating factors being considered on sentence. For the same reason that evidence of remorse really should not be used as an aggravating factor, so too evidence of a lack of cooperation where that was not legally required really ought not to be an aggravating factor on sentence. Evidence of cooperation when it's not legally required should be a mitigating factor, certainly, but not an aggravating factor in its absence. And Ryan and I will certainly, if any of these provisions come to pass as they're drafted, be preparing constitutional motions arguing exactly that these provisions, when we get to the sentencing stage, violate the accused's right to fair trial, violate their Section 7 and Section 11B rights, rather Section 11D rights, and we'll see what happens, along with all other lawyers on the defense bar. But these are very concerning, and I'm not sure where these factors came from. I'm not sure what think tank provided these to the government when they drafted these, but I think they have to go back to the drawing board on a number of them because they're highly concerning, at least in my respectful view, and open to significant challenge under the Charter of Rights and Freedoms. Changing gears a little bit, this is an issue that unfortunately has been hitting home throughout North America and elsewhere in the world. Oxycodone and other opioid related addictions are a serious problem, and there have been a number of situations where overdoses were fatal or caused long-standing disablement where they didn't have to. And there is a treatment called naloxone, for those who are not familiar with it, which essentially is it's a nasal spray, or it can be given as a nasal spray. It typically comes in vials with a syringe, and then you sort of put the syringe into the bottom of that device and you squirt through the device while it's in the individual's nose, and that naloxone can instantly essentially stop at least as I understand it, an opioid overdose from becoming fatal, at least long enough for that individual to be stabilized and rushed to the hospital. So there is certainly an argument to be made from a moral standpoint that this is something that companies, for the same reason before things were required, a lot of companies went out and got defibrillators that could be kept in the workplace where that was appropriate. Similarly, something like this may very well be a reasonable precaution in some circumstances, or something that just from a moral standpoint is a good thing to do, especially in the current climate of opioid and substance abuse generally. I will say that it's unclear what the basis for the quote unquote risk of a worker having an opioid overdose at a workplace will be before an employer under this legislation is then required to have an naloxone kit. So for example, will it be that someone has disclosed in the course of an accommodation inquiry, they've said they have to be off work while they go through some sort of a rehabilitation or something like that they have an opioid addiction, or that they're on opioids for medical purposes? Would that be sufficient? Is it enough for there to be rumors in the workplace? Is it enough for there to be a lot of opioid addiction in your particular community where the plant is located or where the facilities are located? Really, it's not all that clear, and hopefully there's a little bit more information provided. In any event, though, it may make sense, given the widespread nature and the fact that this does appear to touch all strata of society and all cultural groups. I don't think there's any reason for us to conclude that in our workplace this can't happen, right? I mean, our people would never do this. No, this is touching all aspects of society. And so it might make sense, just as a precautionary measure, to consider getting training and ordering one of these kits. In many communities, they're actually free, provided from local health units, if you would like one for your workplace. And training comes with it. It's not actually that complicated. It's a one-page sheet, and you can watch videos online. So all I will say is we'll wait and see what the legal requirement is here, but a lot of employers may decide to put these in place regardless. And now Ryan and I just have sort of a few practical thoughts to take us to the end.
Yeah, I mean, just to sort of build on some of our the points we've been making, is I think there's assuming this legislation passes, that there's going to be an attempt by prosecutors to seek higher penalties against individuals. How successful those attempts are going to depend on what direction the courts take, particularly with first offenders, but certainly for multiple offenders. It's going to be crystal clear that if this is not your first time before the court, you're going to be potentially subject to a higher penalty than an employer would have been previously. The more recent the conviction, the more significant, and the more number of past convictions under various regulatory statutes, that becomes important. Secondly, prosecutions against officers and directors, I think, may very well become more common. I think it's perhaps signaling a policy intention from the government to head in that direction, where those prosecutions, although not unheard of, are not certainly a regular occurrence, not nearly as common as prosecutions against supervisors and workers. Remembering that supervisors is a fairly broadly defined term in health and safety legislation. It does not just mean necessarily the frontline supervisor of an individual worker. It can mean almost anybody in management below sort of the officer and director level. Probably useful as well to look at indemnification, as we spoke to previously, and that issue is more complicated than we have time to get into, but it's certainly something particularly for officers and directors in light of the potentially significantly increased fine range is a question to look at.
Another thing that sort of crosses both comments Ryan and I made are it really becomes more important now to challenge questionable orders from inspectors. In the past, dealing with simple non-compliance with the Act was unless those orders directly related to the charges that are later before the court, those orders might not be relevant. Whereas now with these proposed regulatory changes, any order from an inspector, which really stretches credulity, and they really ought to be thinking about whether or not those orders should be challenged to the labor board. You might want to think harder about challenging those orders now, even if it's just to raise that and for the board to dismiss the challenge as moot because the issue is no longer relevant. There won't be a record which shows that there are orders which were made against you, which are proof of non-compliance with the regulatory scheme. Second, it really might take longer for charges to get laid, and so once you've been subject, well, frankly, most of our clients contact us, before midnight on the day that an inspector shows up following an accident anyways. Ryan and I are used to that. But for those of you who have been going through an investigation that has taken some time, at a certain point, you're going to want to have a broader discussion with your counsel about the point at which they really ought to be giving cautions to your supervisors and to your managers, at which point they ought to be getting warrants to continue with their investigation, which is now an investigation into the likely commission of an offense, as opposed to simply conducting an inspection for regulatory compliance. Keep in mind that pre-charge delay, if it goes up to 2 years, unless there's evidence of bad faith, which is almost never going to happen, they will have 2 years to lay charges against you if these changes come to pass. And so that will mean doing what you can to ensure that you have counsel, that you're complying with orders, considering whether that Rubicon has been crossed, and that you take steps to indicate remorse while simultaneously hedging against evidence of post-accident steps, which could be used as evidence of an admission that you hadn't taken those steps before. So this is sort of careful balancing that we often help our clients with. Ryan, do you want to deal with the last two?
Yeah, sure, absolutely. Legal advice, again, so it's self-serving, the lawyers to say so, but it is essential with respect to the cooperation issue. I mean, assuming that sentencing factor is valid, I mean, the only sort of constitutional way I could see of reading that term is cooperation, meaning cooperating where you legally have to in terms of issuing critical injury or fatality notices as required, producing documents as required, engaging in conduct that is, subject to the mandatory inspection powers of the Ministry of Labor. I mean, historically, people who didn't cooperate with the Ministry of Labor in that sense would be typically charged with not filing a critical injury notice or obstructing an inspector for failing to produce documents as required. But I mean, again, that might be the most narrow reading of that, in which case most employers probably wouldn't need to be concerned about it. But you do certainly, that's certainly a much broader way. It could be read in a much broader way, and that's where you need to get some advice. Yeah, and I think consider proactively training. Jeremy spoke to the naloxone kits, and I think that I think that there's going to be a lot of, as there often is in these circumstances, well, do we have known risk? Do we not? Maybe it's just one of the best advice might just be just to get one, regardless of known risk, and just train on it, because it probably that's the easiest way to do. As Jeremy said, they're readily available. It is not overwhelmingly complicated, and it's probably easier to do that than engage in some sort of amorphous process as to determining whether you're at risk or not. Anyway, so those are our formal comments. As we're reaching 1 o'clock, Jeremy, I'm happy to stick around. Jeremy, do we have any questions so far?
No, we don't have any questions. One individual had some issues with audio, but those appear to have just been confined to that individual, and someone else was commenting about the, rather than a question, was commenting about the lack of sort of empirical evidence to support an increase to the fines, that it's sort of unclear why all of a sudden we've got this. And of course, that's for the prosecutors to argue, as Ryan said, was done because the legislature wanted to signal that they wanted to hold officers and directors, for example, more responsible than previously, and for defense counsel to argue that they would have set a minimum fine if that's what they really meant to do. And then we'll wait and see how that comes out in the wash. We do have a few questions here. Well, there's a couple of questions dealing with the employment standards revisions that are proposed, which we have promised not to cover here today, and we're not going to get into them. Then there is there's a question here about the likelihood that this legislation will pass, and I suppose Ryan got into this a little bit at the beginning. Maybe you want to extrapolate.
Yeah, I would say that it's very likely to pass. I would be astonished if it didn't. Premier Ford has a majority government, so it's not like there's likely to be any ability on the opposition to stop the bill, even if they wanted to, which I doubt they would. In fact, the opposition might even be a little bit more aggressive on it. So the chance of this becoming law, I would say chances are, there's nothing's ever a certainty, but I'd say chances are excellent.
Okay, so I guess for what it's worth at this point, we've passed second reading. It's carried. Okay, that was someone's asked about sort of the status of this. March 23rd, it carried on second reading, but it's back to committee. So hopefully that as it's back to the Standing Committee on Social Policy and is still being reviewed on that basis at this point, the government will make some changes before they continue with these some of the more concerning provisions that we've discussed today. I mean, as Ryan said, given the government is in a position to really rubber stamp its own proposed legislation, we'll see how many changes are made. See if we have any other changes here. Okay, we've got a couple of people saying, okay, now I'm scared. I don't think that was our point, Ryan, but I mean, certainly due diligence when it comes to saving your own skin and your director and officer's skin is an important thing to do at all times. So
yeah, I mean, certainly one of the goals of regulatory legislation is in fining and the sentencing process is general deterrence, to generally put I'm not saying a massive fear out there, but certainly to put people on notice that there are serious consequences for violations. And you know, I mean, that I'm afraid is the point from the
unfortunately perspective. All right, so it looks like those are all of our questions at this time. Give it another couple of minutes, see if any new questions come in, and if not, as always, our slides will go out following a link that you will be directed to if you complete a survey on the feed, giving us some feedback on how this session went. We really do rely on those. Ryan and I review them carefully to ensure that, and others from our firm review those to ensure that we're sort of staying on the forefront and that we're addressing issues of concern to the folks who join us. And hopefully you do take that time. There is one question, maybe Ryan, you could handle this in the last minute. We'll make this the last question, and it is a law school exam question. You're welcome. So is there no way to debate the potential mens rea element?
Okay, I mean, you've asked like mens rea, which is like, you know, fancy lawyer speak for intent. Essentially a mental element of the offense. Is there a debate? Sure. I mean, certainly, and there has been much historically ink and type and trees killed over the years debating whether a particular regulatory offense is either an absolute liability offense, i.e. the act happens, you're guilty. Strict liability offense, the act happens, you can you're guilty subject to a due diligence defense, or a full mens rea offense in which the Crown has a burden to prove a mental element. And there are debates about specific provisions, but without getting into the whole, first year criminal law deep dive into this topic, which every first year law student in Canada has invariably read the Regina versus Sault Ste. Marie and the other sort of Supreme Court foundational cases on this. Basically, intent is where it's just how a statute is written. We're an example of an OHS offense that has intent is obstruction of an inspector, right? Like you have to, obstruction of an inspector is an intent. Certainly, you have to show that the accused intended to obstruct the inspector. It's a mental element. That's where it's a full mens rea kind of offense. The vast majority, overwhelming majority of offenses in occupational health and safety are strict liability.
It's a good point. And obviously, if you're dealing with a mens rea aspect on the Gardner stage, as opposed to on a violation of the actual provision stage, then the considerations are similar but different, right? So you're not proving guilt. You're demonstrating the severity of the penalty that would be appropriate based on the factors that the court would be required to consider. And one of those would be mental in nature. And that's where those Gardner hearings happen following the trial on the merits.
Yeah, so, that's where where that evidence hasn't been called on the trial proper. So that means, long story, sort of technical stuff, but yeah, it may very well be that if these provisions come through, that actual full-blown sentencing hearings where evidence is called and argument is made more than just a joint submission, which is sort of where the Crown and defense agree to a penalty subject to the court's approval, which is generally granted unless the court finds the penalty.
And this presentation today is not a deep dive into how you cross the Rubicon and when you're obstructing versus when you're complying with a lawful order. So anytime there's any doubt as to whether a direction or an order from an inspector is valid and you must follow it, you better call counsel, gotta say, before you decide not to comply with an order of an inspector, because it isn't very difficult for them to prove they gave you an order to do something, you didn't do it. So before you take any of those positions, certainly give Ryan or a call and let us hold your hand a little bit through that. So with no other further questions coming in that I think are appropriate to answer here today. Thanks again to everyone who joined us and for your very, I think, thought-provoking questions and comments. Those are always appreciated. Please do complete the feedback survey that you'll receive probably not today, maybe tomorrow or the day after, and you will receive a copy of the slides on the link there. Also, if you missed some of this presentation or you want to send a copy to a friend who might have missed it, we will post the video from this webinar session in our media center on our website, probably by the end of the week, okay? Thanks very much, everyone. Have a great afternoon.